Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert, and I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law.
Feel my faith rising. I'm crawling out the trenches, holding me.
So today we're jumping right in talking about non-disclosure agreements. Nearly all businesses have confidential information, and for many, that confidential information is a valuable asset. Protecting confidential information must be a business priority, and the non-disclosure agreement is meant to keep that confidential information from being released. For the purpose of this video, I'm going to use non-disclosure agreement and NDA interchangeably. So an NDA agreement should not be confused with a non-compete agreement. I've talked about non-compete agreements in the past, and I'll link that video down below in the description box. Just for clarification, a non-compete agreement prohibits an employee from competing with their former employer, such as forming their own company within the same geographical location and offering the same or similar goods or services. While these two agreements do complement each other and sometimes have overlapping provisions, they do have very different intentions. So let's talk about three types of NDAs that you could actually encounter. First, we have our unilateral NDA, where one party discloses confidential information to the other, and that other party is expected to protect and keep that information confidential. The second type is a bilateral NDA, where both parties exchange confidential information and they agree that neither will disclose any of that information to any other third party. Lastly, we have a multilateral NDA, and that's where three or more parties exchange confidential information amongst each other, and they all agree that they will all protect it from being disclosed to anyone outside of that agreement. So what type of information should actually be protected? Information such as client list, which in some states can be considered trade secrets, marketing plans, pricing and discount structures, inventions and business methods, production processes, products, plans and designs, recipes and chemical formulas, software algorithms and source code, and generally any information that meets the following criteria. Number one, any information that is generally unknown outside of the owner's organization or control. Number two, any information that provides economic value or a business advantage to its owner because it's a secret. Kind of like the Coca-Cola recipe. Nobody knows how to make it, and that's what keeps us buying it. Or the Google algorithm. No other search engine is quite as accurate as Google. And that's why we keep using it. And number three, information that the owner takes reasonable steps to try to keep a secret, such as either encrypting it or restricting access to it. So if you've gone through the process of encrypting your data and protecting your information, you may wonder, why do I actually need a written NDA? Why can't I just rely on the informal processes that I've already set up? Well, here are 5 reasons why you should have a written non-disclosure agreement. Number one, you need to avoid confusion over what is actually considered confidential. Number two, you need to outline the expectations of what the parties are supposed to do with that confidential information and what they can't do, whether they are the disclosing party or the receiving party. Number three, when somebody starts to have selective memory over what we agree to, if you have it in writing, it's going to be so much easier to enforce over an oral agreement. So put that joint in writing. Number four, in some states, you only get maximum protection over trade secrets and other confidential information when the agreement is in writing. And number five, you need to look the part of a professional. Most commercial transactions and relationships have standard expectations, and contracts are one of those expectations. So now that you know what types of information should be protected and you know why you should have a written agreement, let's talk about what should be included in that written agreement. And more importantly, how to get out of it. So, a non disclosure agreement must include some key elements. As I mentioned before, we need to state exactly what is considered confidential. Then we need to set some boundaries. Like, who else can this information be shared with? Can it be shared with the receiving party's employee? Can it be shared with law enforcement? Should it be shared if there's a court order? If the information can be shared, what should happen before that information is shared? Should that receiving party have to give notice to the disclosing party that they're about to share some of their confidential information? This all goes into the non-disclosure agreement. Your NDA must also be clear on all the parties who are involved. An NDA should also include how long a party must protect that information. Should the information be protected forever? Should it be protected for 5 years? Should it be protected for 5 years starting after the contract actually ends? What are you seeking to protect, and how does that affect your business? Lastly, the non-disclosure agreement should note the legal consequences for disclosing confidential information or violating the non-disclosure agreement in any way, and how to handle those types of disputes. If you have already signed a non-disclosure agreement and you're looking for a way out, there are a couple of ways that you could approach this. You could wait for the contract to expire. This is a primary method for many, but it's a long and passive way to get out of a non-disclosure agreement. The second approach is that you could look for a termination clause in the agreement. A termination clause is a provision within the contract that allows you to end the contract early. Sometimes early termination may be subjected to a penalty or some other stipulation, such as returning all of the confidential information or destroying it. Another way to get out of an NDA is to look to see if the language in the contract is broad or unreasonable. If so, the NDA can be challenged or invalidated in court. The scope of an NDA should be limited to protecting business practices and property information, not general workplace behavior. Another important element that you can challenge in an NDA is the balance of power. In order for an NDA to be enforceable, typically there needs to be a balance of power, which means that all parties to the NDA should be able to negotiate the terms of the agreement. Lastly, if you somehow reverse engineer confidential information, such as the Coca-Cola recipe that you just played around with and somehow got it exact to Coca-Cola, or the information becomes public knowledge without you leaking it or misappropriating it, of course, then an NDA can no longer be enforced. Ultimately, when it comes to NDAs, the best way to protect your confidential information is to not share it at all. But if you must, then you need to determine exactly what needs to be shared, and an NDA is a great tool to help protect that information. That's all I have for this video. I hope it helped you to understand a little bit more about non-disclosure agreements. Let me know your questions in the comments, and until next time, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.